Hi, my name is Nick Weiss. I am the founder and managing attorney of Weiss Law. I want to talk about will contests and particularly the process that goes through when you're doing a will contest. So let's start from the beginning. We have a will. You think, or it is invalid, and you need to find a way to prove that. Common reasons for the invalidity of a will: there could be a defect in actually signing the will. In Ohio, you need a will to be in writing. You need to have two witnesses sign saying that the person who wrote the will and signed on the will did so in their presence and was competent to do so. So there could be a defect there. Maybe they don't have the necessary witnesses. Maybe the person signing didn't actually see the person sign it in front of them, or the testator didn't come to them and actually tell them that. There can be a couple of defects there in the actual process of putting the will together. Other major reasons for invalidating a will would be lack of testamentary capacity. That is, the person had some kind of inability to understand what it was that they were signing. This does not necessarily mean that they have dementia, Alzheimer's, that they have some kind of mental defect, but certainly those are attributes and aspects that you can raise to show that this person didn't actually understand what it was they were looking at, reviewing, and signing. This criteria is a little bit different than general incompetence. A person can be not capable of maintaining their lifestyle, but is capable of reviewing the will and saying, yes, these are the people that I want to receive my things, and these are the things I want them to receive, which is generally all a will is. Finally, the most difficult area to contest a will is what's called undue influence. That is where you believe that a third party, maybe a beneficiary, maybe a sibling, forced through their influence to make this person who is making the will write this will against their interests. This can be through threats. This can be through just pressure on a person, particularly if you're looking at major changes in a will that change who is going to be receiving the estate's property, and now it's going to that person. There can be a variety of things that you can establish there. So those are your three main ways to challenge a will: is some kind of defect in executing, some kind of lack of testamentary capacity, or undue influence. So what do you do? First, you consult with an attorney. This is not something you want to try to do yourself. For any of these things, these are very complicated to litigate, and the burden is on you. You have to overcome a presumption that everything was fine, right? That's a lot of work. So you first need to talk to an attorney to make sure that this is even worth pursuing. Many wills, in fact, have something in them called an interim clause, or sometimes called a will contest clause, that says if any of you contest this will, say this will should not be valid, then I prohibit you from taking in the estate. That's a very, very common clause. So if you shoot your shot to try to invalidate the will and you lose, then it's possible you get nothing. And that's so common that I've yet to see a will that we do one of these on where that clause is not in there. Okay, so that's something you need to talk with your attorney about when you do it. You need to also talk about what kind of evidence that you have and what evidence you're going to need to provide, because the court is not going to be real sympathetic if you come in saying, I just know it, I just feel it in my gut. You gotta have something. So let's presume you go through all those hurdles. You've talked to an attorney, you have some evidence of this, you want to go forward. You start with a petition. Your attorney is going to petition the probate court, where that will either has already been submitted or is going to petition to invalidate it before that will has been submitted for the court's review. This is the equivalent to a civil complaint in any other court. And so once that is filed, the other side, usually the person who is asserting this will is valid and who is taking most of the estate, has the opportunity to answer that complaint, and because of that in interim clause, also has the ability to prohibit or seek to prohibit you from taking under the will. And that's the start. What we have right there, we now have a complaint, a petition that seek to set aside this will, and we get into it. We get into what's called the discovery process. That is the process whereby any interested party who's been added to the complaint can seek documents relevant to the complaint. Maybe those are medical documents, maybe those are emails, maybe that's correspondence between people, maybe that's financial documents showing that there's some kind of financial undue influence. That can include subpoenas for deposition. You just want to talk to the other side. You want to see what kind of information that you can get. And that can be parties, that can be doctors, that can be bank executives, that can be whoever has relevant knowledge on this. Or that could just be the submission of written questions that you get back. And that part is very standard in any litigation, including will contests. All right. Once you have all of that together, it is very likely that the court is going to submit this to some kind of mediation, some kind of third-party body who is going to see if all of the parties can find a resolution to the will contest. If you can resolve it there, great. The case is done. We figure something out. Maybe the will is invalidated. Maybe it's not invalidated, but the person receiving the proceeds agrees to give something else to you. Something like that. There's a lot of wiggle room on how to structure those kind of settlements. The settlement doesn't work, right? Now we have to try the case, and we try it like any other case. So that is gathering your witnesses, gathering your documents, gathering your experts, presenting them all to the probate court for trial to prove that this will, for whatever reason, is invalid. These are complicated. These take a long time, and there are risks to you if you fail to successfully invalidate a will because of that no contest clause. So, not to be entered in lightly. If you have questions about this, please call our office.